Greetings and welcome to Torts, Wrongful Actions and Breach of Duty, Part 3. We're going to be getting into prima facie tort and some of the defenses. And just before we get started, to remind everyone this is strictly for the entertainment educational purposes of this YouTube channel, not to be used, misconstrued, or mispurposed for anything legal, lawful, personal, private, business, tax, financial, or otherwise. So please don't do this at home. That said, let's get started. And just checking here, did notifications go out? If so, just give a heads up in the chat because they didn't go out earlier. That's why I rebroadcast this. Anyhow, let's get started with this, and hopefully people will come in and get the notifications because I didn't. So we're on a prima facie tort. Just a second here. Excellent. Let's get started. I didn't get a notification, and I saw there was no one in the room. It still shows there's no one there. All right. That said, let's get started. So we're on to the prima facie tort generally. Prima facie tort is a narrow catch-all remedy for intentional malicious acts that cause special harm and aren't covered by other tort laws. So the Supreme Court has ruled that intentional causing temporal harm is a valid cause of action, so for any amount of time. To escape liability, the defendant must provide a legal justification for their actions. It is a narrowly restricted remedy for otherwise lawful conduct. Conduct must not be actionable under another tort. So we're looking at a special harm that's not covered by other torts. So it must not be actionable under another tort. Otherwise, it wouldn't qualify for a prima facie tort. It requires a malicious intent to harm the complainant, resulting in special damages and without justification. So we got here from Smith versus Meridian Technologies, and I believe this is in New York, 2011. A claim of prima facie tort does not lie where the defendant's action has any motive other than a desire to injure the plaintiff. So we're talking about wicked and evil deeds here. And that would qualify for a prima facie tort. So we're looking at a conduct that's not actionable under another tort, but it's something that is narrowly restricted and for special damages. Again, something done without justification. It's no other motive than a desire to injure the plaintiff. That makes it a prima facie tort. So let's continue. There's particular conduct as constituting part of constituting. All right, particular conduct is constituting is what we're looking at here, prima facie tort. Not all courts recognize prima facie tort, and those that do stress it as limited remedy, not a blanket fix for all intentional harms. So we're looking at a limited remedy again, very restricted application, something that there is no other motive other than that intentional harm. Some jurisdictions recognize it to provide remedies for wrongs outside traditional tort categories. Other jurisdictions refuse to recognize it, believing courts can simply create new specific torts as needed. As we discussed earlier, there is an ever-evolving tort law as it's needed to adapt to differing social changes, conditions, circumstances. Even where recognized, courts emphasize it is not intended to provide a remedy for every intentional caused harm. It is reserved for acts committed with a specific intent to injure the plaintiff and without justification. So that's the particular conduct constituting a prima facie tort. So we have here from the Mosley versus Titus, 2010, I believe that's New Mexico. Attorney had sufficient justification to file lawsuits against a doctor on behalf of his workers' compensation clients, and the attorney's justification outweighed any alleged improper motives for filing the suits, precluding the doctor's New Mexico law prima facie tort claim against the attorney, his partner, and his law firm. Wow. So this precluded the doctor. He tried suing, it seems here, the attorney that was trying to sue him on behalf of his workers' compensation clients. So he tried suing the attorney's partner, and his law firm. The lawsuits did not affect price that the purchaser paid for the doctor's practice or cause the doctor to lose any patients. So he was precluded from suing those attorneys because those lawsuits did not affect the price people were paying for the doctor's practice, and it didn't cause the doctor to lose any patients. So the doctor wasn't able to show those damages, seems here, and he wasn't able to prove, it seems, the motives that the attorney was filing the suits to try to cause harm. So you can see where that tort would fail, especially if you're looking at a prima facie tort. And I guess in New Mexico that might be one that's available. This doctor tried it, seemed it didn't work. Let's proceed. The necessity for malice, Section 38. Malice is the cornerstone of prima facie tort claim. The defendant's sole motivation must be to harm the plaintiff with no other purpose. Without malice, there is no prima facie tort. The defendant must have acted with an actual intention to harm the plaintiff. The malicious intent must be separate from any other motive. The sole motivation must have been a malicious intention to injure the plaintiff. Any other motive, such as profit, self-interest, or business advantage, completely precludes recovery. Now, this is strictly for the prima facie tort, which is specialized and not applicable in all jurisdictions. However, it is a very special type of remedy, I guess you'd say, in damages and situations where it would be applied. Malice must be the exclusive motive for a prima facie tort claim. Now we're on the necessity for special damages. These are special situations. A plaintiff cannot succeed on a prima facie tort claim without provoking specific, quantifiable, special damages, not just general harm. So special damages here is a term. An allegation of special damages is an essential element of the cause of action. The plaintiff must allege special damages with sufficient particularity. There must be a showing of special damages as distinguished from general damages. There must be proof of actual temporal damage resulting from the defendant's acts. So, particular time. If specific torts already account for all damages sustained, a prima facie tort will not lie. So special damages must be proven with particularity to support a prima facie tort claim. Now we're on distinguishing from traditional torts, and we'll also go over Section 41, avoiding the statutes of limitation. Prima facie tort is a last resort remedy that cannot be used for conduct covered by traditional torts or to game the system by avoiding shorter statutes of limitations. The distinction here. Conduct actionable under a traditional tort category cannot be the subject of a prima facie tort action. It is reserved for operative misconduct, not otherwise classifiable. So here's our distinction. Traditional tort cannot be the subject of a prima facie tort. So there has to be a clear distinction to make it a valid cause. It is reserved for operative misconduct, not otherwise classifiable. So the operative misconduct, and again, the sole intent to harm the plaintiff. It should not be a catch-all alternative for failed traditional tort claims. So as a last resort remedy, it's not a catch-all alternative. Statutes of limitation. Courts differ on using prima facie tort to avoid the limitations period for specific torts. Some jurisdictions allow it, others deny it if the underlying claim is for a traditional tort, like slander. Prima facie tort cannot be used to circumvent established legal principles. So, there has to be a clear distinguishment between traditional tort and a prima facie tort. And of course, if the tort is something where it could be misconstrued between the two and not easily distinguished, then it could be misinterpreted. Traditional one could be misinterpreted as a prima facie tort and be dismissed on those grounds. So it's very important to ensure that the right type of distinction is closely paid attention to, and of course that statutes of limitation, best just to observe that. If not, the courts differ on using the prima facie tort to avoid the limitations for specific torts. Prima facie tort cannot be used to circumvent established legal principles, though. All right. And let's jump over here to the chat. Not sure if anyone else has entered in, but if so, please hit the like so we get the notifications out. I think they're pretty thin today. All right, we're on to Section 42, the justification or defense generally. If a defendant's act that caused damage has a legal justification or lawful excuse, they may not be held liable for the resulting harm. Tort liability is based on acts that cannot be justified in law. An act causing damage does not create liability if the person has a legal excuse. The justification must be as broad as the act itself, covering motive, purpose, and the means used. So this comes in as the justification here. We're looking at the liability is based on acts that cannot be justified in law. So the illegality, I guess, the unlawfulness of the acts is what causes the liability to the defendant. The justification, if they're going to must be as broad as the act itself. So covering the motive, purpose, and the means used. An unlawful act cannot be justified by arguing a lawful act could have caused an even greater injury. Look at that one. That's an important distinction right there. You can't say we did an unlawful act because if it was a lawful act, it would have caused even greater injury. For intentional torts, the law recognizes fewer defenses than for negligence. So intentional torts, there's less defenses than a case under negligence. Remember that intent and the reckless nature of tort is what really sets it apart. And I think once that's established, there are far fewer defenses. The legal justification must match the scope of the act in question. So lots of fine points there in the justification or the defense. All right, we're on to section 43. Acts or omissions of injured person. Contributory and comparative negligence. So a plaintiff's own negligence is generally not a defense in an intentional tort case, meaning fault is not apportioned between an intentional wrongdoer and a negligent victim. Wow. Traditionally, a contributory negligence was not a defense to an intentional tort. So traditionally, contributory negligence. So that's when a plaintiff's own negligence contributes to the harm. Now, it's not a defense in an intentional tort case, meaning the fault is not apportioned between the intentional wrongdoer and a negligent victim, as it is in cases of negligence where there could be percentages of fault between the parties. This general rule carried over with the adoption of comparative negligence in most jurisdictions. Therefore, it is typically no apportionment of damages where an intentional tort is involved. So no apportionment of damages, absolute here. Some jurisdictions have recently begun to apply comparative negligence principles to intentional torts, but that is not the majority rule. So over here we have Kramer versus Facie in Connecticut 2008. It is the rule of law in virtually all states that fault should not be apportioned between an intentional tortfeasor and a merely negligent victim. Important principle right here, that the intent, the malintent, the wickedness of the defendant here, it's none of that fault can be shared with the victim just because they were merely negligent. All right, we're on to section 44, the criminal or unlawful acts. A plaintiff's involvement in illegal activity does not automatically bar them from suing unless the illegal act is directly related to the injury they suffered. Wow, so even if the plaintiff was doing something illegally when they got injured, if it's not directly from that illegal act, then it does not bar them from suing. Courts do not permit a person to benefit from their own wrongdoing. No claim may be based on an illegal transaction to which the plaintiff was a party. So you can't be a victim to your own illegal transaction here. However, to bar recovery, the unlawful act must have a causal connection to the injury. Otherwise, it wouldn't bar recovery. It has to be causally related. If the illegal act did not proximately cause the injury, the plaintiff can still recover. One is not barred from a recovery for an interference with his title to or possession of lands or chattels, because it was tortuous or illegal for him to have the title or possession. So, if one is, one is not barred from a recovery for interference with his title to or possession of lands or chattels, because it was tortuous or illegal for him to have the title or the possession. So even if you're in possession of something that perhaps it was illegal, that if someone was to cause harm or injury or damages based on the unlawful act, that would still stand as a action for tort, regardless if the situation of possession at the time may have been illegal. That doesn't bar the recovery. So this is important to know, that the involvement in illegal activity does not automatically bar a plaintiff from suing. So let's look at here. A person who broke a tooth on candy won in an illegal bingo game Okay, this is awkward here, but what the story really means is a person who broke a tooth on candy, who was in an illegal bingo game, won in an illegal bingo game, but they could still sue the candy manufacturer, even though they were in illegal gambling here situation, an illegal bingo game. Oh, they won the candy. Okay, so a person broke a tooth on candy. They won so they're playing illegal bingo games for candy. And they broke their tooth on the candy won in an illegal bingo game, and now they get to sue the candy manufacturer. So yeah, torts can be quite unusual. Jeez, be careful. All right, let's see here. All right, looks like the candy was won, but the bingo was illegal. Yes, indeed. All right, I see some other. Oh boy, now the chat's happening here. We get the Shaggy Hippie. Greetings to you. Glad the notifications finally got out. Now they're all doubled up here for me. Yep. Yes, he gifted the document. Bill Thomas says, if lightning hits my tree and it falls on my neighbor's house, it sounds like it might not be a tort because I cannot be expected to know the lightning would strike. Yeah, you're not in control of that lightning. That's an act of God. But yeah, be careful those. If you're playing bingo, I guess the best thing I would say is don't play for candy. All right, that's a great example there. You can't really beat that kind of candy in a bingo game. All right, necessity or self-protection. Actions that are normally torts can be legally justified if done out of immediate and pressing necessity to prevent greater harm to persons or property. An act that would otherwise be a tort may be justified by necessity. Example given, entering land to avoid bodily harm. Those are those exigent circumstances. The necessity must be immediate, imperative, and in some cases, extreme or overwhelming. So that must be the necessity, immediate, imperative, and in some cases, extreme or overwhelming. Mere expediency or utility is not sufficient. The right to self-defense or the protection of property is a natural right founded on necessity. One does not have the right to relieve their own property of a mischief caused by a similar mischief to a neighbor's property. So, yeah, be careful the lightning strikes. One does not have the right to relieve their own property of a mischief by causing a similar mischief to a neighbor's property. Yikes. Necessity is measured by immediacy and seriousness of harms being prevented. All right. Consent, Section 46 and Section 47, lay. Valid consent is a complete defense to tort, while claiming it was just a joke is not a valid defense for causing actual injury. So we have consent. One cannot sue for a wrong to which they have consented. And consent can be expressed or implied and must be reasonable. So it must be reasonable, it can be expressed or even implied, but it must be reasonable. This is valid consent. In lay, a lack of intent to injure is not a justification if an injury does in fact occur. So if you're just joking, that's not would not be a valid defense. The intent to perpetrate a practical joke is immaterial if it causes apprehension or harm. So we have here a tort affecting property might be excused as a joke if the parties had been perpetrating a series of practical jokes on each other in such a way that the defendant has a right to believe that the plaintiff would accept the act as a joke. So you really have to have proof that you've been jostling each other, sparring with jokes and practical jokes of the same degree to have the plaintiff believe that the act would be a joke. So strange circumstances, torts from jokes is no laughing matter. Let's continue. Section 48, we have persons entitled to subject and action generally. All right, let's see what we got here in the chat. Hey, greetings to Auditor Shield, Shaggy Hippie. Indeed. Welcome. Great to have you on board there, and I'm going to be starting to expand a lot of features for members here. I recall a case where a person made a claim against a man's auto insurance for the STD they contracted in the back seat. I do not think they prevailed. We're going to get some backseat cases. I'm not sure in this presentation, perhaps even the next. But yes, salute to you, Shaggy Hippie, and welcome. It'll be quite a treat. There's some good videos too in the member section there that you definitely want to check out. And then we'll get you started with the Auditor's Shield. Okay, so section 48, persons entitled to subject and subject to action, generally. Generally, only the person whose legal right was directly violated can sue, with specific exceptions like loss of consortium for a spouse. A tort committed against one person generally furnishes no cause of action to a third party. The duty must be one owed to the specific individual or class injured. A major exception is loss of consortium, a claim a spouse and sometimes children parents can bring. However, a dependent child usually does not have a derivative claim for a non-fatal injury to a parent. The same act can be a wrong to more than one person, though, giving each a right to sue. Ooh boy. Plaintiff may not recover under an intentional infliction of emotional distress cause of action when the alleged conduct is directed at a third person and the plaintiff was not present when the conduct occurred. Wow. Wow. And that's at Hayes versus Northern Hills General Hospital. I believe that's South Dakota, 2001. Creepy. All right, let's proceed. And we're on to parties, oops, what happened here? Oh, there we go. All right, now we're on to persons not in privity of contract and associations. So modern tort law allows suits from individuals without a direct contract relationship and clarifies the sometimes limited ability to sue associations. We went over the associations and clubs in a previous AmJur. By the way, I guess as a great celebration too, I believe this is the 100th live stream of AmJur on this channel here. I'll check the playlist to make sure, but I believe this is broadcast number 100. So salute to you all for being here on this occasion. All right. We're back to the persons not in privity. So no privity means modern tort liability is measured by the scope of the duty owed, not by an artificial concept of privity of contract. So if you're not party to the contract, you're not privy to the dealings here in the transaction, then there's a scope of duty owed, but it's not by the contract. So this is kind of a shaky area between contract law and tort law. If a legal duty exists independent of the contract, then a tort action may be maintained. But when you're dealing with associations, it's whether a member of an unincorporated association can sue the association depends on the jurisdiction. As we saw, that there are some jurisdictions where they are statutory umbrellas for associations and clubs. Legal duty, not contractual relationship, determines tort liability. So your legal duty, these are good faith, fair dealings, things like that, not the actual artificial concepts in the contractual relationships, determine the tort liability. And we're on Section 13, intrafamily lawsuits. Family members can sometimes sue each other in tort, but courts are hesitant due to policy concerns about family harmony, as we read earlier in the previous episode, that family harmony is one of the key goals of tort, to focus on maintaining that, especially when there's any kind of intrafamily affairs here, often making insurance a key factor. Jurisdictions are in conflict on whether parents, children, or spouses may sue each other. The main reason for denying such suits is to prevent disruption of family harmony and fraud. But this immunity generally does not apply to siblings or other kin. Courts are more likely to allow suits, though, when insurance is available to pay for the judgment, as it does not deplete family assets. Oh, how nice. Family harmony versus individual rights. The Judicial Balancing Act. When we forgot, though, insurance will tip the scale. Let's proceed. Okay, we're on to injury to inanimate objects and to the environment. To sue for environmental damage, a plaintiff must show a specific, legally recognized interest, a standing, not just a general concern for the environment. The core question is, who has standing to sue? A mere interest in an ecological problem is not enough. For example, a state does not have a property interest in wild, untamed fish sufficient to support a tort action for their destruction. So if someone destroyed the untamed fish, I guess, as opposed to the tamed fish, then the state doesn't have a property interest that's valid to support a tort for their destruction. Similarly, a conservation club's general interest does not grant it standing to sue for environmental preservation. Standing requires a direct personal stake in the environmental harm. And I've seen some creative ways of this. There's ways of measuring the ecological services, they're called. This is how it's monetized, right? Like, for instance, there's studies, and I guess there's ways you could actually monetize or show you're accounting for the ecological services that a particular type of service a forest would provide, or a mangrove estuary. And it would be calculated per square meter, let's say, that so much bioproductivity, so much oxygen per day, per cubic foot, or whatever it might be. But they actually have cases where they have come with these types of ecological services attributed to environmental, say the estuaries, other places that are important environmental resources, and we're able to monetize them in an accounting context where they're able to bring these types of actions against perpetrators of destroying the environment for profit. So in some of these ways, there is creative approaches that have come about. Now, this text is from, I believe, 2012, so there's been a lot of changes. As we've been reading, tort law is made to adapt with changing environmental, social circumstances. So, but the principles still stand, and that's why we're going over this. All right, that takes us to our conclusion here. But before that, we need to get to this comment here from Bill Thomas, who mentions that I think oysters farmed near me counted as tamed fish in a case against. Yes, I believe so. And let's see here. I got some other ones here. Shaggy Hibbs says, I don't know how long I'll be able to keep Otter Shill, but looking for your videos. Yes, and definitely even just the one membership is really all it would take. We also provide nice little packets if you do want to get more involved with accessing some of the things that are featured within the Auditor Shield. So definitely it's an addition to the channel. These are things that YouTube has been kind of encouraging encouraging me to do here, and also to add in some live stream, members only live streams with panels. So we'll be doing that too in the future. I believe we got to keep our generous corporate sponsors pleased and satisfied with our performances here, so they'll continue to reciprocate their generosity with allowing this great platform and reach. That said, let's get to our conclusion here. Our key takeaways. Prima facie torts serve as a narrow, exceptional remedy for intentional, malicious harms that are not covered by traditional tort law, but they require proof of special damages, very particularly documented special damages. The defenses, such as justification, necessity, and consent, can excuse otherwise tortuous conduct when grounded in law or public policy. So these are the ones a lot of the public serpents get away with because they'll use these defenses. So this is the ones you want to definitely focus on: justification, necessity, and consent. We went over those in details. Again, the necessities, especially just because of utility, is not enough. It has to be almost extreme. Standing to sue is generally limited to those whose direct legal interests were harmed, with specific rules governing family members, third parties, and environmental claims. So lots of restrictions there. Tort law reminds us that with every right comes a duty, and with every harm, a search for justice. And I think that encapsulates the dynamic nature of tort law indeed. All right. With that said, I would like to thank you all for joining here tonight as we continue our search here for getting the full grasp and knowledge of torts, the wrongful acts, breach of duties. This was focusing on the prima facie torts and the general defenses we find to torts. And next we'll be going over some more interesting yes, thank you very much. That was a goal, was to get 100 episodes of AmJur on the channel, and finally did it. So there it is. But we have lots more to go. I got a lot more on the burner here, and we have to finish with torts because I get a lot of feedback that this is an important topic. It's been a lot overlooked, and I think it really needs to be taken apart. I thought it would originally be 2 parts. It's going to end up being 5 parts. So we're on part 3. It's downhill from here. So please join me for the next one. And thank you all for coming. Salute to you, Shaggy Hippie, for joining the Auditor Shield. Look forward to hearing from you more, and definitely check out the videos there, and any other questions, I'll be happy to answer. That said, thank you all for coming, and we'll see you all on the next one. Peace out.